Good morning, sir. Vanakkam.
Good morning, sir. Vanakkam.
Sir, last year for Nation Chennai, we have produced a video for GST registration and we have described the procedures and all that. In the past 1 year, we see the disputes between the GST applicants and the departmental offices in processing the registration. Now I understand some advisories have been issued by the board to address this issue. Can you explain me what are the recent instructions in this regard?
CBIC has recently issued instruction number 3 of 2025. It was issued on 17th April 2025. This instruction aims to streamline the processing of GST registration applications by standardizing document requirements while preventing arbitrary or irrelevant queries by the officers and ensuring genuine applicants are not harassed while preventing fraudulent registrations.
Sir, as per these instructions, what documents the departmental officer can demand from the applicants?
Officers must strictly adhere to the list of documents prescribed in Form GST Reg 01. This Form Reg 01 is the form for applying for registration. They cannot ask for additional documents beyond this list unless prior approval is obtained from the jurisdictional assistant or deputy commissioner.
Sir, mainly this dispute arises in respect of the document for the address proof of principal place of business. So, what are all the prescribed documents for the address proof of a principal place of business, sir?
So, the premises for which registration is sought may be of several types, such as owned premises, rented or leased premises, shared premises, premises in SEZ, that is Special Economic Zone. So, I will tell one by one. For owned premises, any one document such as latest property tax receipt or municipal kata, electricity or water bill, or any other document prescribed under the state or the local laws establishing the ownership of the premises is sufficient. No originals or extra proofs are needed. In respect of rented or leased premises, a valid rent or lease agreement plus one ownership proof of the lessor is required. If the rent agreement is registered, lessor's ID is not required. If unregistered, a simple ID proof of the lessor is sufficient. For premises other than owned or rented or leased premises, like the ownership of the premises may be with the spouse or relatives, in such a case, consent letter from the owner along with one ownership document of the consenter is adequate. No additional document should be sought. For shared premises, a rent or lease agreement along with one ownership document as mentioned earlier are required. If the agreement is not registered, additional documents regarding identity proof of the lessor is required. There may be cases where rental or lease agreement is not available. In such situation, the applicant is required to provide a consent letter along with the identity proof of the consenter and any one document in support of the ownership of the premises of the consenter. In respect of those applicants located in special economic zone, or if the applicant is a special economic zone developer, documents, certificates issued by the Government of India are required to be furnished.
Sir, you mentioned the term municipal kata. What do you mean by that, sir?
Municipal kata is a legal document issued by the local municipal authority in India, and it essentially identifies a property and its owner or owners for the purpose of property tax assessment.
Sir, you also mentioned the word shared premises. What do you mean by shared premises?
Essentially, it means the space is not exclusively for one person or entity, but rather it's intended for shared use. For example, co-working spaces, professionals such as lawyers, consultants using the same office, common areas in shopping malls like food courts.
Sir, while mentioning about shared premises, you mentioned that if there is no rental agreement or lease agreement, a consent letter is enough. Whether this is only for shared premises or it is applicable for all the cases.
It is applicable only for shared premises. In other cases, if no rent or lease agreement is available, then the applicant has to submit an affidavit to that effect along with any document prescribed, as I mentioned earlier, in support of the possession of the premises. Affidavit has to be executed on non-judicial stamp paper of minimum value in the presence of first-class judicial magistrate or executive magistrate or notary public.
So now in respect of partnership firm, what are all the documents required for GST registration?
For partnership firms, only the partnership deed needs to be uploaded as proof of constitution of business. No additional documents like Udyam certificate, MSME certificate, shop establishment certificate or trade license should be required from the applicant.
Sir, what documents are required for societies, trust, clubs, government departments, and such other entities?
For entities such as societies, trusts, clubs, government departments, association of persons, bodies of individuals, local authorities, statutory bodies, and others, the registration certificate with regard to the status or proof of constitution must be furnished.
Sir, now one important question. Whether officers are allowed to ask any presumptive questions during GST registration process?
No, officers are prohibited from asking presumptive queries or questions unrelated to the documents or information submitted by the applicant, like residence of the applicant and business addresses are not in the same city or the premises is not suitable for conducting the business. The proper officer may very well cross-verify from the publicly available sources such as websites of the concerned authorities like land registry, electricity distribution companies, municipalities, local bodies, etc. for confirming the authenticity of the documents submitted.
Sir, can you tell me what is the timeline for GST registration applications?
Applications not flagged as risky should be approved within 7 working days. For applications flagged as risky, the process including physical verification should be completed within 30 days.
Sir, is there any specific instruction on how to report the results of physical verification?
Yes, specific report has to be given regarding existence or non-existence of principal place of business declared by the applicant. In case the entity is found non-existing, efforts made in respect of locating the said premises need to be recorded in the physical verification report. You have to upload on the portal GPS-enabled site photograph and other documents, if any, during physical verification visit. In case the ARN assigned for physical verification belongs to a different jurisdiction, the same should immediately be reassigned by the concerned officer to its correct jurisdiction through the portal.
Sir, you said the proper officer should not make any presumptive queries. But in case where there is some discrepancies noticed, or if he thinks that the document is inadequate, how he can proceed further, sir?
The proper officer can seek clarification if the document is incomplete or not legible, where the address of place of business does not match with the document furnished, or if it is incomplete, where any GSTN link to the PAN of the applicant is found cancelled or suspended. So, in these circumstances, the proper officer can seek clarification from the applicant.
Sir, you have described the various instructions of the board. Can you tell me how it would help the applicants?
The instruction helps in reducing unnecessary delays and harassment by limiting document requests and queries to only what is necessary and prescribed, thereby facilitating faster and smoother GST registration for genuine applicants.
Sir, when the measures are taken to address the issues of the genuine taxpayers, what measures have been taken to address the fraudulent assessees and fraudulent registrations?
The board instruction balances ease of registration with safeguards by allowing physical verification of the flagged applicants within 30 days and ensuring officers follow standardized procedures to detect and prevent registrations created solely for fraudulent input tax credit claims.
So now I could understand the instructions of the board. Suppose if we encounter any difficulties while implementing these instructions, to whom we have to address, sir?
If any issues or difficulties are faced in implementation of this instruction, the same may be reported to the board through email at gst-cbic@gov.in.
Thank you, sir. You have explained the provisions of this board circular. Let us believe that this will solve the disputes between the applicants and the departmental offices. Thank you, sir.
Thank you very much, sir.